So we thought the NRA was finally on board, but it was not. The NRA then, finding out that they could not proceed with the case, the court went to Congress and tried to get the DC gun ban repealed. Now, ordinarily that's a good thing. But if you repeal the gun ban, you moot. That's the legal term. And the lawsuit, and by moot, I mean the case gets thrown out. The lawsuit can't challenge a law that no longer exists. So if the law is repealed, the Heller case goes away. The case would be dismissed by the court. So I actually testified in Congress against repeal of the DC gun ban. I made it quite clear to the Congress that I was in favor of repeal of the DC gun ban, but not by Congress. I thought it ought to be done by the courts. Why? For two reasons. One is a decision by the Supreme Court would have nationwide implications, whereas a decision by Congress would only affect Washington, D.C. And second, the Supreme Court is the highest authority in the land. Congress changes every 2 years. So every time Congress changes, there is the potential that any repeal gets reversed, and it gets reinstated. So that was a major lobbying effort, and we finally got that bill modeled on the D.C. gun ban. It was not repealed by Congress, and the NRA finally joined forces. When they decided to join forces, they are a formidable ally. And they filed a very important brief in the Heller case, which was signed by a majority of all the House representatives in the House, majority of all the senators in the Senate, and by Vice President Cheney in his capacity as president of the Senate. Well, as they say, the rest is history. In PCB Heller, which is the final opinion of the court's 2008 term, Scalia effectively rewrote the court's Second Amendment jurisprudence and held first the Second Amendment protects an individual right for self-defense, even if unconnected with militia service, and second, that Washington, D.C.'s ban on all forms of firearms is unconstitutional. Now, let me close by commenting briefly on
about 10 minutes left for Q&A.
10 minutes? Mm-hmm. Okay. I'll comment very quickly on a couple of issues that receive less attention, but I think have significant implications for the future. One is what gun regulations will now be permissible, and the second is what did the court say regarding the applicability of the Second Amendment to the states, and that was the follow-up case. Scalia acknowledged this first issue, what gun regulations are now permissible. By the way, late breaking news, I'm sorry to say this, the U.S. Court of Appeals for D.C., the very same court that decided favorably in the Heller case, issued an opinion this morning. I haven't read it because I just got news over the email that said that Washington, D.C.'s ban on what they call assault weapons and on magazines with more than 10 rounds is constitutional, even after the Heller case. So this is a three-part issue. Part one, what's the Second Amendment mean? That was taken care of in the Heller case. Part two, where does the Second Amendment apply? I'm going to talk about that in just a second. That was in the Donald case. Part three, what does the right, what's the scope of the right? What kind of regulations still going to be permitted? And that's going to be fleshed out over a long period of time, maybe a decade. And it's happening right now in one decision that I mentioned today. So how do we know which rights are going to be approved and which rights are, which regulations are going to be approved and which regulations are not? Scalia said in his opinion that the court has occasionally sanctioned concealed carry. He certainly prohibits guns from being carried by crazy people or 7-year-olds. Everybody understands, even the most rabid gun rights advocate understands that the right to keep and bear arms doesn't mean that a 7-year-old can have an automatic weapon in front of the White House when the president is delivering. So quite clearly there are some things that can be regulated. That's the whole issue about those rights. Absolutely. What this is going to boil down to is what level of scrutiny does the court apply to reviewing regulations. This is a very complex legal issue. We hope that the court will require the government to jump through 3 hoops in order to justify regulation. Bear in mind that because Heller is decided in favor of the plaintiffs, and the court did decide that there is an individual right. The effect of that decision is to shift the burden to the government. It is now up to the government to justify its regulation. It is not up to us, if we want to carry a gun, to justify that we need to do so. It is up to the government. We would hope, in reviewing these regulations, that the court will rigorously review the government's proof that the regulation is necessary and will require three things of the government. First, that the need for the regulation is absolutely critical and help. Second, that what the government proposes to do in the way of regulating is going to be successful at accomplishing the ends that the government seeks to have. And third, that he couldn't have accomplished the same thing in a way that wouldn't have trampled on the Second Amendment rights. We don't know what standard of review the court will apply. We will know more as these decisions are fleshed out. What did the court say about applying the Second Amendment to the states? Heller resolved the meaning of the Second Amendment, but EC wasn't the whole story, so we have to look at Donald versus Chicago, which was resolved in 2010, and that found that the Second Amendment applies not just to federal enclaves like EC. Imagine that the Second Amendment only applies to EC, Guam, Samoa, Virgin Islands, and Puerto Rico, but not to Illinois. So the Donald case found that the Second Amendment does apply to the states and localities as well as federal enclaves. And as I said, that's why we filed in D.C., because we didn't want to deal with that on the first case. The second case, the Donald case, to deal with that. Now, here's what some of you may not know, unless you study constitutional law. Until the 14th Amendment was ratified after the Civil War in 1868, the Bill of Rights only applied to the federal government. You notice if you read the First Amendment, it says Congress will make the law, and it's anything but the states. So the state of Maryland could pass a law that says you can't practice Catholicism. You can't criticize the government. Now, maybe that would have violated the Maryland Constitution. It would not have violated the federal Constitution, the U.S. Constitution, because the Bill of Rights did not apply to the states. It only applied to the federal government. We found out over the first 70 or so years that the states can be every bit as tyrannical as the federal government, slavery being the obvious case in point. And so we fight a civil war, and we have a number of post-Civil War amendments, including the 14th Amendment. The 14th Amendment says that no state can deny to persons due process of the law, equal protection of the law, and privileges or immunities of citizenship. The 14th Amendment was used to apply the Bill of Rights to the state. So because the federal government was given the authority to step in and stop the states if they were found to violate speech, press, religion, unreasonable search, etc. Because of that, the 14th Amendment is said to have incorporated the Bill of Rights, so it applies to the states. This process didn't all happen in one fell swoop. So we would have cases litigating the right to free speech, whether that applied to the states, religion, press, unreasonable searches, and until 2010, the McDonald case, no one had ever addressed whether the Second Amendment applies to the states. And the McDonald court determined that it indeed applied to most of the other provisions in the Bill of Rights. The Second Amendment, right to keep and bear arms, does apply to the states. What that means is that should spell the end for some of the draconian state and local regulations that constructively bar the use of firearms for self-defense. Now, it may be that sensible regulations will still be allowed by the courts, and I, for one, applaud it. But sensible has to be properly defined, and sensible is not what we have. We're certainly not what we had in D.C., not what we had in New York, Chicago, or many other major cities. Thankfully, I think Heller and McDonald. Heller took the major step to restore sensibility, and McDonald took the second step in making that apply applicable nationwide. And I think that is a big win for common sense, and more importantly, it's a big win for the U.S. Constitution. So thanks very much, and I'll answer whatever questions.
Question about property rights and gun rights. Here in Utah during the last legislative session, I think there was a bill introduced by one of our local legislators that had to do with, say, a hotel owner doesn't want a gun on his property. How do you feel about that? You know,
well, here's one area where the KO Institute and the NRA differ. this came up in the context of whether or not a corporation could include guns, right, being held in automobiles on corporate property. The NRA said this is a Second Amendment. I don't think it's a Second Amendment issue at all. The Second Amendment, bear in mind, the Constitution is not a code of conduct for individuals. The Constitution is a restriction on the behavior of government. That's what the Constitution is all about. So unless government misbehaves, the Second Amendment doesn't apply. There's no misbehavior when this is private property. Our position in Cato is, not the NRA, but our position is that a private property owner should have the right to permit only gun owners to be on his property, only non-gun owners, neither of them, or both of them. And we should be able to permit that for good reason, for bad reason, or for no reason whatsoever.